I think there were some bench conferences that that are fairly historical that you wanted to memorialize, but also a new motion based on events this weekend. Mr. Nelson.
Correct, Your Honor. Your Honor, as the court is aware, and as prior to coming into court this morning for closing arguments, we had an in-chambers discussion about events of this weekend, specifically referencing that an elected official, United States congressperson, was making what I interpreted to be, and what I think are reasonably interpreted to be, threats against the sanctity of the jury process, threatening and intimidating a jury, demanding that if there's not a guilty verdict, that there would be further problems, Your Honor. And given the fact that this jury has not been sequestered, it has been my position all along throughout the course of this case that this jury should have been sequestered at the outset. The jury has not been continually told to stay away from media, only media, about this case. There is a high probability that members of this jury have seen these comments, are familiar with these comments, and things that have happened throughout the course of this trial. I mean, it's unfortunate that there was another situation that occurred during the course of this trial. But obviously, Your Honor, we also, as I mentioned previously too, one of the jurors does live in the city, Brooklyn Center, as I recall.
Although I think that is the alternate we just dismissed.
I do not believe so.
I thought it was, but go ahead.
Now I'd have to go back and double check my notes. So, Your Honor, I mean, I just think that the sum total of this trial happening in such a public context, I mean, number one. Number two, while all of this, I mean, the media attention is profound. I've admittedly stayed away from 99% of it, but that has required me to stay away from all media. I mean, this case has found its way into even fictional television, Your Honor. There were I was advised of 2 television shows in the course of the past few days that specifically involve references to this particular case and the reactions of the characters in these stories to this particular case. This jury has, despite all best efforts, has been bombarded with information relevant to this case. It is impossible to stay away from it unless you literally shut off your phone, or you shut off your TV, you shut off your computer. And no such instructions have been given during the course of this trial.
Well, to be fair, the last few times I've advised them, I told them don't watch the news. Pure and simple.
Right, but if you can't even watch your favorite Thursday night television program and it comes up, I mean, this is the problem, right? And why I have felt that this jury should have been sequestered from the very beginning.
Understood.
To make that clear. And so I had moved, based on this, again, for a mistrial. The idea is that it is a public trial. I think the court has accomplished that, but the media attention is so profound. It is such a, I mean, it is such a modern comparison. I mean, it's such a modern problem to have, where literally I walked from this courtroom into the courtroom where I have been permitted to stay. During the course of this trial, I've received literally thousands and thousands and thousands of emails. So much so that I don't even look at that particular email anymore. So, I mean, but my phone gives me alerts on things that just happened. I mean, you can't avoid it. And it is so pervasive that I just don't know how this jury, it can really be said to be that they are free from the taint of this. And now that we have U.S. representatives threatening acts of violence in relation to this specific case, it's mind-boggling to me, Judge.
Well, I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned. But what's the state's position?
Your Honor, the state's position, first and foremost, and this is a concern I raised at the beginning of the proceedings, well into jury selection, is that we can't allow statements like this, vague statements, to be considered a part of the record on appeal. If there's a specific statement that a specific U.S. representative made, then there needs to be some sort of formal offer of proof with the exact quotes, the exact statement, or some kind of a declaration. And I'm sure Mr. Nelson can do that if he thinks that that's something that's appropriate. I don't know that this particular representative made a specified threat of violence. I don't know what the context of the statement is. I also don't know what television shows Mr. Nelson is referring to in terms of any of this, and so I just don't think that we can muddy the record with vague allegations as to things that have happened without very specific evidence.